Hello, good evening everyone. This is our discussion about Chapter 1. Again, this is part of your prelim coverage, and the prelim coverage will be this week. Okay, so yeah, let's start. So first article in Chapter 1 is Article 1156. This provides that an obligation is a juridical necessity to give, to do, or not to do. So, one of the very important things that you have to take into consideration is the meaning of the word obligation. As you know, as you have read in your book, obligation comes from the Latin word obligatio, which means tying or binding. Okay, so it is a tie of law or a juridical bond by virtue of which one is bound in favor of another to render something, and this may consist in giving a thing, doing a certain act, or not doing a certain act. Because, you know, as what is stated in Article 1156, an obligation is a juridical necessity to give, to do, or not to do. Okay, so what is that thing called juridical necessity? What is a juridical necessity? A juridical necessity means that there is a necessity, meaning in case of non-compliance, the courts can be called to enforce the rights of one of the parties. Okay, so this means that it is necessary, and because it is necessary, you can go to the court. Sa ato apano pwede tang magpalaban sa korte to enforce the obligation. Okay, so in a proper case, the debtor may be held liable for damages. Okay. So, what are the essential requisites of a valid obligation? So, in this case, you have to take note of these four essential requisites. This is usually asked in exams. I'm not sure if you will have a departmental examinations, but in the ordinary course of business, meaning before the COVID pandemic, RFBT 1, RFBT 2, RFBT 3, all of these subjects will have to have a, anong tawag nito? There is this thing called departmental examinations, but I'm not sure if you will have a departmental examinations. Still, you have to take note of them, remember them by heart. As what I've mentioned, this law, obligations and contracts, is one of the very important laws that you have to remember. This is an essential component in your RFBT subject, which you will take in your board exam later on. Okay, so enough about the reminder. Again, the essential requisites of a valid obligation. You have number one, ouch, a passive subject, also called the debtor or the obligor, the person who has the duty to fulfill an obligation. And then you have an active subject. This is your creditor or your obligee, the person who has the right to demand, yung pwedeng mag-demand ng pagmamahal. Charot. Siya yung may karapatan, kumbaga. Okay? And that person is entitled to demand the fulfillment of the obligation. Siya yung may karapatan. He who has a right. That person who has a right is called the active subject. The person against whom that right is demanded is called the passive subject. Okay? O, di ba? Active, my right. The one na my left, charot. The one against whom the obligation can be demanded is the passive subject. O, di ba? Madali lang i-remember. Next, you have your object or prestation. The object or prestation is a subject matter of the obligation or the conduct required to be observed by the debtor. So this is what you are supposed to do. It can be that you are obliged to do, to not to do, or to give. Okay, without this, there is nothing to perform. Because again, in 1156, an obligation is a juridical necessity to give, to do, or not to do. The to give, to do, or not to do there is your object or prestation. Okay? And number 4 is your juridical tie, or also called the efficient cause. Usually in exams, there is a question regarding this one. What's another term for juridical cause, or what's another term for not juridical cause, but juridical or legal tie? So the answer is, it is efficient cause. Okay? That efficient cause binds or connects the parties. So, kaya nga legal tie kasi it binds the parties. Diba? So, the tie in an obligation can easily be determined by knowing the source of the obligation. Okay? So, you also need to take note of the difference between obligation, right, and wrong. An obligation is the act or the performance which the law will enforce, whereas a right is the power which a person has to demand from another any prestation. Yung karapatan niya, no? Right, not left. Charot. It's the right. Okay? And wrong, yung kamalian. Charot. Wrong is your cause of action. So according to its legal meaning, it is an act or omission of one party in violation of the legal right of another, causing injury to another. For example, 'di ba? Yung boyfriend mo, charot, naghanap ng iba. Your right is to demand an explanation. The wrong there is, mali siya kasi humanap siya ng iba. Ayun, nasa piling na ng iba. Charot. Again, you need to distinguish the difference between obligation, right, and wrong. Okay? This is like self-explanatory, no? The word speaks for itself. Yes. And then you have the, let me look at the book. This is the book of the Prophet de Leon. Let's follow this one. You have the different forms of obligations. This one, I think this was included in your wonderful exam. So the form of an obligation refers to the manner in which an obligation is manifested or incurred. So it can be oral or in writing, or partly oral and partly in writing. So as a general rule, you can enter into obligations orally. So as a general rule, there is no need to write everything so that you can incur an obligation. Okay, so you can go into oral contracts, and then as a general rule, they are valid. However, there are certain contracts which will need that you put them in writing. So again, going back to your obligation, the obligation can be either done orally, in writing, partly orally, and partly in writing. Okay, so questions so far? Okay, if you have questions, kindly comment down below and I'll try my best to answer them. Okay? So next kinds of obligations according to the subject matter. So you have two major kinds. You have a real obligation and a personal obligation. If it's a real obligation, or it is an obligation to give, the subject matter is a thing which the obligor must deliver to the obligee. So again, real obligation. You must distinguish this from real right, because when we talk about a real right, it is a right which is demandable against the whole world. Okay? However, if we talk about a real obligation, this obligation is an obligation to give. So the subject matter is a thing which must be delivered. Again, do not confuse this. When I was younger, I was confused. I was thinking, real right, real obligation, because, real. Real na real, real na real. Dan, 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 dalan, dan. Hindi. Real obligation is different from a real right. And you have to distinguish the two of them. Okay? Okay? Okay. Next, going back, you have real obligation and then personal obligation. Again, to reiterate, in a real obligation, you have an obligation to deliver a thing, because the delivery of the thing is the subject matter of the obligation. And then you have a personal obligation. In a personal obligation, the subject matter is the act to be done or not to be done. Okay, there's a positive personal obligation and a negative personal obligation. If it's a positive personal obligation, it is an obligation to do. If it is a negative personal obligation, it is an obligation not to do. Okay? Diba? For example, obligation. Obligation to love. Charot. Mana siya? Anong puro matagugma-gugma? For example, taxes. You have an obligation to pay your taxes. Okay, so that's your positive personal obligation. Or it can be that you have a negative personal obligation. It can be that you entered into a contract wherein you bound yourself that you will not construct a fence for a particular period of time. So you have a negative personal obligation because you have an obligation to not do an act, and that act is to not construct a fence. Okay, G. Again, there are two kinds of obligations according to subject matter. First, you have real obligation. Second, you have personal obligation, and personal obligation is divided into two major components. You have the personal positive obligation and negative personal obligation. Okay, and that's about 1156. Again, 1156 talks about an obligation, which is a juridical necessity to give, to do, or not to do. Okay? Okay. Next, we go to 1157. 1157 talks about the sources of obligations. And the keyword here is la quasi-delicts. La quasi-delicts, la is law. La quasi-delicts. Co is contracts. Qua is quasi-contracts. And delicts is the acts or omissions punished by law. And quasi-delicts. La quasi-delicts. Parang may mali. Basta. Kamo na yung mag-igo, ana. Okay, so again, law, contracts, quasi-contracts, acts or omissions punishable by law, and quasi-delicts. So let's talk about each one of them individually. Okay, first you have a law. A law is that which is imposed by the law itself. For example, as stated in your book, you have an obligation to pay taxes or an obligation to support your family. Of course, also because it is imposed by law, like for example, we have our obligation to wear a mask. But you know, right now I am in the soup. Charot. If you're following BTS, you know that they are in the soup right now. They are promoting Dynamite, but they have na sila show na in the forest. So, tada, like me, in the forest. This is where I grew up. Currently, I'm in Sambuan, visiting our grandmother. Mm-hmm. Mm-mm. So, if you will hear her, that's my mother. Ingon siya, "Nangin naman mag-varnish na! Bahaw gani! Naradere!" Okay, so let's continue. So that's the law. Second is your contracts. Contracts is a meeting of the minds whereby one binds himself with respect to the other to give something or to render some service. So if there is a contract, there is a meeting of the minds, there is an agreement or a stipulation by the parties. Because of your agreement, you have an obligation. And then you have quasi-contracts. In quasi-contracts, there is no contract, but then there is an obligation arising out of that something. It arises out of a lawful unilateral voluntary act by one person. And these are enforceable because no one shall be enriched at the expense of another. So these obligations may also be considered as arising from laws. But, you know, basically, these are quasi-contracts. And you have to remember that there are two kinds of quasi-contracts. But later on, we will be discussing them. Okay, and then you have crimes or acts punishable by law. So there is an obligation, a civil liability, if there is an act punishable by law. Acts or offenses punishable by law. Like for example, if you commit a crime of homicide or of murder, you know, these are two things. Homicide, hindi mo siya sinadya. Murder, there's evident premeditation, meaning sinadya mo talaga na patayin siya. Homicide is like a general term also. It's like, nakipag-away ka sa isang tao, tapos hindi mo siya, hindi mo in-expect, pero nadunggab mo siya, charot, na ano yung nadunggab? You stabbed a person and that stab wound eventually led to his death. In that case, that is homicide. It's not murder. It will be murder if you really thought of killing the person. Anyways, in either of these cases, these are acts punishable by law. These are criminal acts, and because these are criminal acts, you will be criminally liable. Aside from your criminal liability, you also have a civil liability, and that civil liability is your civil obligation. Okay, so why are we talking about this? We are talking about this because, again, this is obligations and contracts. We are talking about civil laws. We are not talking about criminal laws. So, ano siya? Just to give you an idea na in our law, you can be held liable for two things. Like if you commit one act, like for example, you killed a person accidentally or otherwise, you can be held liable for two things. First, you can be held criminally liable. Second, you can be held civilly liable. And we are talking about civil liability here because we're talking about obligations and contracts. And this is, again, as what I've mentioned in our previous video, this one is about civil laws. Okay? Civil laws. Next, so you have laws. Again, to recap, you have laws, you have contracts, quasi-contracts, you have acts or omissions punishable by law, and then you also have quasi-delicts or your torts. These torts or these quasi-delicts are obligations arising out of acts na hindi mo naman sinasadya, pero nagawa mo pa rin, okay? There is damage to another through an act or omission, there being fault or negligence, and no contractual relation exists between the parties. So in quasi-delicts or torts, it's different from a crime because in quasi-delicts or torts, there's only fault or negligence, and you can only be held liable for damages. You cannot be held criminally liable, okay? Like, for example, you have the obligation of the possessor of an animal to pay for damages. For example, you have a dog named Wiwo, and Wiwo will bite another person, and that other person will suffer, will be rabies. Rabies? So, gano'n, oo, yon kanang basta marabisan siya, no? Yun sa Bisaya. Pag Tagalogin natin, maano siya, antaktan o rabies. Charot. Maon sa yan? Ay basta kana siya. So, if you are the owner of that animal, you have an obligation um, pay for damages caused by your own animal. Okay? So, quasi-delicts or torts, it's also a separate subject if you would proceed to law school. So, it's a separate subject. It's a 2-unit subject. And it's quite complicated, but it's kanang fun. So again, you will be held liable for damages. So you will not be criminally liable, meaning you will not necessarily be imprisoned, but you can be held liable for damages, meaning you will have to pay for damages. Okay? So, 'di ba, yung sa mga salida, sinasabi nila, I will sue you for damages or something like that. So, this is it. Okay, again, to recap so you won't forget, and you can just go back and ting ting ting, rewind and ting ting ting, forward, and basin inyohan ni siyang times 2 times, no? 2 times ang ako ang lecture. So, depende ra gyud ninyo. So again, lakok delics, you have laws, contracts, quasi-contracts, acts or omissions arising from, or acts or omissions punished by law, and you have quasi-delicts. Okay, do not forget them. These are the sources of obligations. Okay. So next is 1158. Obligations derived from law are not presumed. Only those expressly determined in this code or in special laws are demandable and shall be regulated by the precepts of law which establishes them. And as to what has not been foreseen or by the provisions of the book. Okay, so again, legal obligations or obligations arising from laws are not presumed. Okay, so the law must be clearly set forth. Okay, that's why when you file a case in court, you have to specifically cite a certain law which is violated. Okay, because your obligation is arising from law, so there must be a law which you violated. You can just say, mao magud ni siya, di mao gini siya nga mo ang kuan. You can just say na, you can just randomly say something without legal basis. That's why you can say, okay, this is a violation of Article 19 of the Civil Code, or this is a violation of Section 1 of RA 8424, etc. So you have to specify the source of the law. Okay, because again, in 1158, it says it's not presumed. 1159 talks about your obligations arising from contracts. It has the force of law between the contracting parties and it must be complied with in good faith. Again, as what I've mentioned, a contract is a meeting of the minds between two persons whereby one binds himself with respect to the other to give something or to render some service. And if these two contracting parties, enter into a contract voluntarily, willingly, they must comply with the contract in good faith. Okay, and the obligation arising and your obligation, or there is an obligation for you to comply, because you have to comply because in the first place nagsabot mo. Okay, you agreed upon something, like for example, you can enter into a contract of sale for a plant. For example, this one, okay? You entered into a contract to sell a plant later on. So you have to comply with it in good faith. Okay, so you can just say, okay, I will sell to you this plant which I don't know the name, and this is what you promised, but then you delivered another plant. Nangibot ako diri randomly. Ayaw mo kabalaka no. These are very kanang mga kuan ni bitaw sila, mga kanang sagbot sa katilingban, charot. So this one, feel nako I can sell this no for like 100 pesos, charot. Basin og pwede ni nako siya ibaligya sa syudad og 5. Ibutang lang ako siya kaang nalaysyo. Okay, so again, if you have an obligation to deliver something, it must correspond to that thing, because again, it must be complied with in good faith. And you have requirements of a valid contract. We will talk about them later on when we go to contracts, because this is obligations and contracts. First part is obligations, next part is contracts. So yes, we got to do what we have to do. Again, compliance in good faith, this is performance with the stipulations or terms of the contract or agreement. Okay, and if the contract is contrary to law, it is considered void. For example, I will contract a person to kill another person, so that is invalid. So you can say, "Oh, I have complied with it in good faith." So you cannot do that, because in the first place, the contract is void for being contrary to law. Okay, so you cannot ask a person to kill another person. Okay, that's wrong. My God, obligation, right? Or that's wrong. Anyway, 1160, obligations derived from quasi-contracts shall be subject to the provisions of Chapter 1, Title 17 of this book. What are quasi-contractual obligations? As what I've mentioned before, there are two major kinds of quasi-contractual obligations. Again, to reiterate, what are quasi-contracts? These are lawful, unilateral, voluntary, LUV. Do not forget. Lawful, unilateral, voluntary obligations which must be complied with, because no one should be enriched at the expense of another. Kung i-translate natin to, walang pwedeng maging mayaman sa expense ng iba. Charot lang. What this means is that, one person should not be enriched at the expense of another. So, yeah, it means just that. Hindi mo pwedeng, paano ba yun sa Tagalogin? Hindi ka pwedeng umangat at the expense of another. Hindi mo pwedeng yurakan ang karapatan ng iba para lang ikaw ay makaangat sa lipunan. Charot. So, pang MMK na siya na level, no? But that's the concept behind this one. No one should be enriched at the expense of another. So you have two kinds. You have solosyo indibeti and negosyorum gestio, and these are very simple obligations, but these are very applicable in our daily lives. Like for example, for negosyorum gestio, this is the voluntary management of a property of another or affairs of another without the knowledge or consent of that person. Like for example, your neighbor went to Korea to visit the oppa saranghe, and then while your neighbor was in Korea, there was a typhoon coming, and then you saw that hala, the tree is about to kanang fall. So what did you do? You cut the tree so that you know, there will be no accidents later on. And because you cut the tree, you expensed, you were able to spend something. So in that case, when your neighbor returns from Korea, you can ask for reimbursement from your neighbor because you voluntarily manage the property of another and there is no consent or there is no contractual obligation between the two of you. Another example is if, like, for example, you have again another neighbor and the other neighbor went to London to visit the Queen, and then while that neighbor went to London to visit the Queen, the house was on fire, and you know, you were so kind and generous that you sacrificed yourself and you spent something to turn to put out the fire, or to put out, yeah, that's correct, to put out the fire. In that case, you can ask for reimbursement from your neighbor because again, no one should be enriched at the expense of another. Okay. Next, so that's negotiorum gesture. That's voluntary management of the affairs or property of another. Next, you also have this thing called solusyo indebeti. Solusyo indebeti is payment by mistake. Okay, so you paid something because you thought, I have to pay this, but then hindi pala, no? So it is a juridical relation which is created when something is received, when there is no right to demand it, and it was duly delivered through mistake. Again, you have no right to receive it, and the thing was unduly delivered through mistake. So I think the common example of solusyo indebeti is when you pay the driver 10 pesos and the driver will sukli 5 pesos because, you know, nalipat ng channel ang driver. Charot, diba? Our 5 peso and 1 peso coin at the very beginning is very confusing. Even until now, like if you won't really look at it carefully, wonderfully, and you will not ding dong, hindi mo siya tutukan 24 oras. Charot. If you will really not look into it, you can be wrong. So, yeah. So, going back. There's solusyo indebeti or payment by mistake if, like, for example, you paid 10 pesos and the driver is supposed to give you a 1 peso change, but then the driver gave you 5 pesos kasi nalipat ng channel. So what are you supposed to do? You have to return and you have to tell the driver, Manong, nasobrahan po yung yung sinukli nyo sa akin. Because there is more or less payment by mistake. It was unduly delivered through mistake. You have no right to demand 5 pesos. Your right is only up to 1 peso. Okay? So later on, if makagawas na mo sa inyong balay, you have to, you know, return what was unduly paid to you. Payment by mistake. Okay, this also happens when, for example, you are indebted to someone and then you thought that you are indebted to this other person and then you paid to this person, but then that person is not pala your creditor. So that person to whom you paid has an obligation to return the thing because there was payment by mistake. Again, payment by mistake is your solusyo indebeti. Okay, that's 1160 quasi contracts. Again, in quasi-contracts, there is no pre-existing contractual obligation between them. There is only a lawful unilateral voluntary management of one person, and the what you call this? The principle is that no one should be enriched at the expense of another. And then you have 1161. This one talks about your criminal obligations, your civil obligations arising out of criminal offenses. It shall be governed by the penal law, subject to the provisions of Article 2177, etc., etc., etc. As what I mentioned, if you are criminally liable, you can also be held civilly liable. And the scope of your civil liability is your restitution, reparation for the damage caused, and indemnification for consequential damages. So restitution, you have to return what you owed. Like, for example, if there is a person who is convicted for the crime of theft of a cell phone, so restitution, that person is obliged to return the thing if the thing is still there. But if the thing is not there anymore, then he can be liable, or he can be liable for the value of the thing. And then there's also reparation for the damage caused, and then indemnification for consequential damages. Like, he can be held for other damages. Like, there are 5 kinds of damages, and the acronym is mental. We have moral, exemplary, nominal damages, temporate, actual, and liquidated damages. Mental. 6 pala, no? I'm so sorry. So, again, mental, moral, exemplary, nominal, temperate, actual, and liquidated damages. And I will not ask you about this one because, again, this is another 2-unit subject in law school. This will be discussed when you will be talking about torts and damages. Yeah, torts and damages. It's a 2-unit subject in law school. Ano ba siya? Second year or third year subject? Yeah. Anyway, 1162. Obligations derived from quasi-delicts shall be governed by the provisions of Chapter 2, Title 14 of this book, and by special laws. Okay? Again, in a quasi-delicts, an act or omission caused by fault or negligence. Hindi mo siya sinasadya, pero nakakause ka ng act or omission. You caused damage to the person or to his property. Okay, take note of the requisites of a quasi-delict. Number 1, there must be an act or omission. So there must be an action or an omission, meaning there's an act which you failed to do. So, like for example, instead of observing due diligence, you failed to instead of braking, not breaking up, but instead of pressing the brake pedal in your car, you accelerated instead. So what happens? You can be liable for quasi-delict. Not necessarily a crime, because wrongly stepping on the pedal of your car is not a criminal offense, but it is an omission. Okay, an act or an omission. Okay, there is fault or negligence. There's a difference between fault and negligence, and we will discuss that later on, or later on. And then there is a damage caused. Like for example, okay ra unta kung okay lang sana kung for example nagkamali ka ng pagtapak ng gasolina ay ng brake. So instead na brake, tinapakan mo yung gasolina, so you accelerated. It's okay if you don't hit anyone or anything, but it's a problem if you hit a property or if you hit a person. So if you hit a person, that's reckless imprudence resulting to maybe damage, homicide or damage or something. But in that case, if it's reckless imprudence resulting to homicide or serious physical injuries, then it will not be quasi-delicts anymore. It will now become an act punishable by it's now an act punishable by law. So there is now a criminal aspect to that, because it's reckless imprudence resulting to homicide or reckless imprudence resulting to damage to properties. Okay? Anyway, let's not talk about them in detail because kana siya pang law school level na siya, kani siya dapat ang accountancy level sa ta. Okay? There must be a direct relation or connection of the cause and effect between the act or omission and the damage. So, for example, ano pa bang may example natin dito sa mga acts or omissions causing damage? Like for example, you failed to provide a kanang pool watcher, pool watcher. Yung nasa pool, yung nagte-take care yung person na sumasagip ng mga people pag may nalulunod. Na kagaya ko, hindi marunong mag-swimming. So like if you fail to provide for preventive measures, or if you fail to provide for someone who can oversee and make sure that everything is safe, so you can be held liable for damages. And if that failure is the direct cause and the direct reason why, for example, someone drowned or someone died out of drowning, because you can drown and not die, or you can drown and die. So your act or omission can make you liable, or can make you become liable. Oh my God, my brain cells. 3 na lang kabuok, hindi ko na alam. Okay, so again, then there is no pre-existing contractual obligation between you because it's quasi-delict. If there is a pre-existing contract between the two of you, then it's an obligation arising out of contracts. Okay, so And then you have crime distinguished from quasi-delict. Take note of this one. This is also usually asked. In crime, there is criminal or malicious intent. In quasi-delict, there is no criminal or malicious intent. It's just that there is fault or negligence, no? Sa ato pang language sa Bisaya, nagtanga-tanga, nag-angach-angach. Okay? In criminal, if it's a crime, there is a malicious intent, meaning pinag-isipan mo talaga na patayin siya or something, syugiin siya. In crime, the purpose is punishment, but in quasi-delict, it's indemnification, meaning you have to indemnify, bayaran mo yung kasalanan na nagawa mo, but it's just monetary compensation, not necessarily na you will be imprisoned, okay? But if it's a crime, if it's an obligation arising out of crime, the main purpose is punishment. Next, you have crime affects public interest. That's why if it's a case, if it's a criminal case, it's people of the Philippines versus Dyan, people of the Philippines versus Juan de la Cruz. However, if it's a quasi-delict, you can file a case in court and you can say, private offended party like Dyan versus Jong Ho Sok, ganon. Because, you know, we'll sue them. Or Marmie Dyan versus Min Yong Gi, ganon. So, however, if it's a criminal offense, and it will be people versus Min Yong Gi, ganon. Okay? Because if it is a quasi-delict, the interest is merely private and not public. So if it's a public offense, it's like the whole entire Philippines is offended. Ganon. That's why it's like people of the Philippines. Okay? Next, in crime, there are two liabilities. You can be held civilly and criminally liable, as what I've mentioned. However, in a case of quasi-delicts, there is only civil liability. Criminal liability cannot be compromised or settled. You can say, Judge, pwede hangyo, pwede di na lang ko mo prisohon, pwede mo bayad na lang ko 1 million pesos and jacket, charot, Judge, bigyan kita ng jacket, wag na lang. Anya, you can't do that, okay? Because if it is an obligation arising out of a criminal liability, you can't compromise it. But if it's arising out of a quasi-delict, then you can compromise it and you can settle it, okay? In crime, the guilt of the guilt of the accused must be proved beyond reasonable doubt, meaning there must be no doubt that that person really committed the crime. However, if it is just a quasi-delict, the act arose out of a fault or negligence, and there's only need of preponderance of evidence. What does this mean, preponderance of evidence? Meaning you can just have enough evidence to support that this person really committed a fault or negligence, and because of the fault or negligence, there is damage to you. Okay, do you understand? Aras to, arayo? Okay, so again, to recap, 1156 is your obligation. An obligation is a juridical necessity to give, to do, or not to do. Okay, so you know what a juridical necessity is, you know what is an obligation, you know what is the two kinds of obligations. You have your real obligation and your personal obligation. Again, distinguish this from your real right and your personal right. These are two different things, okay? And then take note of the essential requisites. And then what else? Your sources of loss, not sources of loss, but your sources of obligations. Take note of the quasi-delicts. You have loss, contracts, quasi-contracts, acts or omissions punishable by law, and quasi-delicts. I believe that I have discussed them to you succinctly a while ago. And if you will reclamo na, Miss, you're so fast, kwenta na yo, because I will upload this, hopefully I will upload this in, yeah, this is already in your wonderful Facebook account, and I think I will also upload this in YouTube, because I believe na YouTube is like more friendly. Because like you can download this one and then you can replay it and then no need to consume data again and again, diba? But in Facebook, diba, you can't download the video. So anyway, last time I uploaded the video via YouTube and I also uploaded it via Facebook, and then I don't know if it is in my class, but some people were saying, why in YouTube it will consume a lot of data, Camerlu. Anyway, I'll try to make this available on YouTube. So if you will find it in YouTube, annyeong. Please click and subscribe, charot. Please like and subscribe, charot lang, etos lang. But yes, this will be in Facebook. This is where you are watching it right now, Facebook. What else? So that's the coverage for your first, for your prelim examinations. And again, you have to read everything. And it's better that if you read in advance. Also, for your midterms. So for your midterms, the coverage is from the very beginning until what we will be discussing. And for your finals, it's from the very beginning until our lab, from the very beginning until the entire everything. Okay, so that's how we are going to proceed with our daily life. Okay, I mean that's how it is. Okay, so if you have questions, clarifications, violent reactions, kindly comment down below. I mean, kindly comment in this post or on this video, and I'll make sure, I'll do my best to answer all of them. Okay, so 정말 감사합니다. 안녕, 再见.